Friends, if there is one provision in the Indian Constitution which is ill fitted to a democratic fabric and which is most often misused is Article 356. Under Article 356, if the President is satisfied that the constitutional machinery in a state has failed, the legislative and executive governance of the state can be taken over by union government for some time. That is popularly known as imposition of President's rule. When can it be said that there is a failure of constitutional failure is a complex question which is not easy to answer always. Article 356 clause 1 merely provides that if the President on receipt of report from the governor of a state is satisfied that the situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, the President may make a proclamation to that effect and impose presidential rule. The determination of the situation, that is, situation is a very crucial condition precedent which this article refers. As far as the consequence of the proclamation is concerned, it involves supersession of the state government and the exercise of the executive and the legislative powers by the union. Here, the satisfaction of the President is actually the satisfaction of the union cabinet on whose advice the President acts. The proclamation made by the President may be varied by another proclamation, and latter proclamation varies the earlier proclamation. All these proclamations require to be laid on the table of the Houses of Parliament and need to be ratified by them. What is the duration of the proclamation of emergency? A proclamation made under Article 356 ends when its term is over unless it is extended or it is revoked before the expiry of this term. The initial term of the proclamation is 2 months. This term of 2 months will be extended to 6 months if before the end of 2 months duration it is ratified by the two houses of Parliament by passing resolutions to that effect. If the Lok Sabha was under dissolution at the time of initial proclamation, or the Lok Sabha is dissolved after the proclamation but before the approval of the proclamation by the House within the stipulated period of 2-month period, then how to determine the duration of the proclamation? In such a situation, if the proclamation has been approved by Rajya Sabha within the stipulated period, the Lok Sabha is required to approve within 13 days period, that is 30 days period from its first sitting after its reconstitution. By following the same process, the duration gets extended by another 6 months. Further, there is a situation where the duration can be extended beyond 6 months and extended up to a maximum of 3 years, provided the following two conditions are fulfilled. Those conditions are: first, that there is a proclamation of national emergency made under Article 352, and secondly, the Election Commission certifies that assembly elections cannot be held because of conditions prevailing during such emergency. Now, let us know the effect of proclamation of emergency. When the proclamation is made under Article 356, legislative and executive powers will pass on to the Parliament and the Union executive respectively. The state becomes during the period virtually a centrally ruled union territory. However, the judicial administration remains untouched because the proviso to Article 356 clause 1 subclause C clearly states that the President is not authorized to assume to himself any of the powers vested in or exercisable by a High Court. Article 356 has been invoked more than 100 times since the Constitution has come into existence. Former Prime Minister Mrs. Indira Gandhi used Article 356 for 27 times to remove majority governments on the ground of political instability, absence of clear mandate, or withdrawal of support, etc. In most of the cases, it is a clear misuse of power under Article 356. The provision is employed to teach a lesson more frequently to opposition-led state governments. In 1977, the Janata Party-led government removed 9 state Congress governments in the wake of massive defeat of Congress Party in the post-emergency elections to Lok Sabha on the ground that these state governments had lost the trust of the people. The action of the union government was challenged in a case, that is State of Rajasthan versus Union of India in 1977. 2 important questions had to be answered by the court in this case. Firstly, under what circumstances may the President rule be imposed under Article 356? And secondly, who decides whether these circumstances exist? In Rajasthan case, it was contended that the court cannot ascertain whether Article 356 can be invoked or not, as it was a non-justiciable political question and is entirely within the discretion of the President. The Supreme Court rejected this contention and held that it was entitled to investigation whether the limits on the power conferred by the Constitution have been observed or there is a transgression of such limits or not. The limit stipulated by the Constitution with respect to Article 356 is that the President had to be satisfied that a situation had arisen where the state government cannot be carried on in accordance with the provisions of the Constitution. The crucial question to be answered is, what is the standard of satisfaction of the President? Can such a standard be laid down by the court? In Rajasthan case, the Supreme Court refused to lay down any standard of satisfaction. Justice Bhagavati said, I quote, "The satisfaction of the President is a subjective one and cannot be tested by reference to any objective tests. There may be a wide range of situations which may arise, and their political implications and consequences may have to be evaluated in order to decide whether the situation is such that the government of the state cannot be carried in accordance with the provisions of the Constitution." Unquote. The Supreme Court dismissed the suit unanimously. The court held unequivocally that it could not interfere with the central's exercise of power under Article 356 merely on the ground that it embraced political and executive policy and expediency unless some constitutional provision was being infringed. Article 356 makes it impossible for the court to question the President's satisfaction on any ground unless and until resort to Article 356 in a particular situation is shown to be so grossly perverse and unreasonable as to constitute patent misuse of power under Article 356. The Janata government at the centre dismissed the 9 Congress-led state government after the court's verdict in this case. In 1980, Congress formed the government at the centre by defeating the opposition Janata Party and dismissed 9 Janata Party-led state governments. These events paved the way for establishing the SAR Commission, which was asked to review the centre-state relations. The Commission inter alia examined the circumstances when Article 356 can be invoked. The Commission had opined that a failure of constitutional machinery may occur in a number of ways. Factors which contribute to such a situation are diverse and imponderable. It is therefore difficult to give an exhaustive catalogue of all situations which would come under Article 356. Still, the Commission identified some conditions under which Article 356 can be excised. The Commission had opined that the cabinet cannot be superseded and the state assembly cannot be dissolved on the sole ground that in general elections to Lok Sabha, the ruling party has suffered a massive defeat. The union government did not accept the SAR Commission report. In the next celebrated case, that is SR versus Union of India, decided in 1994, the Supreme Court was called upon to examine the power exercised by the Union government under Article 356. In this case, the Congress-led Union government imposed President's rule in 6 states. In 3 states, Article 356 was invoked and the state governments were dismissed without allowing rival political parties to prove that they have the majority of the legislature. That is, the majority support of the legislature. In other 3 states, the governments led by BJP had been dismissed in the wake of communal violence after the Babri Masjid demolition. In this case, the court reiterated that the court was entitled to review the exercise of Article 356. Commenting on the court's decision on Bommai's case, the noted constitutional thinker MP Jain opined that the Supreme Court in the case seeks to promote several constitutional values. Thus he said, to promote parliamentary government, the court has insisted that the question whether the incumbent chief minister has lost the majority support or not must be decided on the floor of the House and not by the governor himself. Further, the governor ought to explore the possibility of installing an alternate ministry before reporting failure of the constitutional machinery in the state to the president. To emphasize the federal principle, which the court had considered as a part of basic structure of the constitution, it was opined that the dismissal of a state government is a negation of the federal principle. Hence, this power should be exercised sparingly and scrupulously and with circumspection. Further, the court has emphasized the principle of secularism as basic feature of the constitution and made important observation that if any state government acts in a manner which is calculated to subvert secularism, it can be lawfully regarded that a situation has arisen in which the state government cannot be carried in accordance with the provisions of the Constitution. A state government may enjoy majority support in the assembly, but if it subverts the basic value of secularism, it can be dismissed under Article 356. After Bommai decision, it has become very difficult to invoke Article 356 to dismiss an incumbent government, as the governor cannot decide in his individual discretion whether the state government has lost the majority support, and this issue has to be decided on the floor of the House. The Supreme Court has opined that failure of constitutional machinery in a state may arise because of various factors. These factors are diverse and imponderable. Nevertheless, MP Jain has given a catalogue of situations of the breakdown of the constitutional machinery. They are: first, if no party has a majority in the state legislative assembly to be able to form the government. Secondly, a government in office loses its majority due to defections and no alternative government can be formed. A government may have majority support in the House, but it may act in a manner subversive of the Constitution. The state government does not comply with the directions issued by the central government under various provisions of the Constitution. Security of the state may be threatened by a widespread breakdown of law and order in the state. So, in the first two situations, decision has to be taken on the floor of the House, and as regards situations 3, 4 and 5, the governor may make recommendation under Article 356 in his discretion. The court may examine whether there is a misuse of power and whether the discretion has been properly exercised by the governor under Article 356 or not. This power of judicial review acts as a check against the misuse of power under Article 356. With this, I conclude this presentation. Thank you.